Yes, Mr.
Well, if I may, I'd like to turn next to Glencore. That's in Authorities Bundle 2, tab 24, and there's really just two paragraphs I'd like to take you to and then make submissions.
Yeah.
So, if I could ask you to turn to paragraphs 55 and 56, that's on page 213 of the report.
Yes.
And it's really, whilst we of course accept in our skeleton argument that Glencore and the DPT regime was a different regime, this is obviously still a case of significance and one of wider application than just the regime which was being considered in that case. And we say that paragraphs 55 and 56 are just as applicable as in this case. I just invite you to read those.
Yes.
So in this case, we would say that the statutory procedure that Parliament has clearly identified is the ability to make representations, and only following those representations does certainly on the facts of this case, I'll come on to address my learned friend's point, but only once that process is concluded is there actually an ability on the part of the revenue to enforce the APN. Now, in terms of the point which my learned friend was making about whether his 220 sub 3 and sub 4 point could fall within a representation as to amount. That issue has actually already been addressed in the Court of Appeal's decision in Roe. I propose to take you to that now. So that's just the next tab on behind tab 25. And the first paragraph, if I would like to take you to is paragraph 105. So the main judgment is Lady Justice Arden, she then was, but there's also a passage from Lord Justice McComb, but we're just concerned with Lady Justice Arden here. So if I could just ask you to read paragraph 105 first. So what Mr. Eady is recorded as submitting here is that the revenue accepted you could make representations about effectiveness. They'd have to be, in his words, be a slam dunk, i.e. a sort of rationality challenge.
But are we looking at the same...
paragraph 105?
Yeah, are we looking at the same provision though, or some other provision?
No, we're looking at the same provision.
Okay.
So this is, one is still engaged with this section 222 mechanism in this case. Roe was a case concerning PPNs,
Oh yes.
which are a slightly modified form of APN, where you have a partnership. And just by way of context, Roe was a case concerned with the ingenious partnerships litigation, which is still rolling on. And so the APN, this is the APN limb of ingenious, at least insofar as Roe is concerned.
Yeah.
This case obviously involved vital nuts as well, which was something completely different.
So Mr. Eady conceded it?
Mr. Eady conceded it, but on the basis of a rational, you could only take a point as to a knockout rationality point, a slam dunk point. And that had previously been accepted by Mrs. Justice Simler, as she then was, below. What then happens, if we can just move on, is to go to paragraphs 110 to 111. And I'd also invite you to read 106 for that matter.
106.
106, then 110 and 111. So those passages suggest, at least on one reading, that contrary to the submission made by Mr. Eady, representations are not just restricted to a slam dunk sort of rationality point, but rather the effectiveness of the scheme in general. And this really follows on from an earlier passage in the judgment, which I'm not going to take you to, concerning the role of the designated officer, but for your note, that's paragraphs 56 to 69. Now, whilst the Revenue reserve their position on this to the extent that at this point we're have to go to the Supreme Court, the effect of the Court of Appeal's decision is that, at least on in relation to those paragraphs, is that either representations about the effectiveness of the scheme do fall within section 222, or they would fall within parallel duty to, as a matter of common law, to hear representations. And you'll recall seeing that discussed by Mr. Justice Green in his judgment as well.
In other words, that it would be procedurally unfair to seek to limit the scope of the representations simply by reference to a narrow interpretation of conditions A, B, and C, if there was some other, as it were, overriding reason why the revenue approach is flawed.
But I think where Mr. Justice Green ended up was that it went to the amount. If the officer could conclude that, if he couldn't, well, take a very high case, say that the designated officer couldn't rationally conclude that the denied advantage was, say, £100. The only rational position open to him was zero. Well, according to this part of the judgment, you would be able to make a representation on that point. Whether it's not clear from this passage whether Lady Justice Arden is intending to mean section 222 or a wider general duty of fairness, but
It doesn't appear to be construing the provision. She's dealing with a somewhat higher level about effectiveness and fairness and so on.
She is, and in defence to her, she's at this point of the judgment dealing with she's obviously dealing with the representations mechanism, which she sets out at some length at the beginning of her judgment, up to paragraph 16. But she's also dealing with the challenge made by the claimants as to the fact that the statutory regime fundamentally offends common law duties of fairness as well. And the two, fully accept the word, do tend to merge a bit.
Yeah.
But anyway, I thought I should draw that to your attention.
Thank you.
So what we say on the back of that is, in relation to this this point about section 220, and indeed this really does feed into what my learned friend says about the alleged interdependence of Mr. and Mrs. Archer's claims, is that properly analysed, the Revenue's arguments in relation to Mr. and Mrs. Archer were not at the alternative. And so these points were truly freestanding. The only question really for Mrs. Archer was, could the designated officer properly reach the view that the denied advantage for her, not for her and Mr. Archer in totality, the denied advantage for her was £6 odd million. And then I have the alternative submission in any event that even if there were some sense of interdependence between Mr. Archer's and Mrs. Archer's claims, there are 2 points which would militate against Mrs. Archer issuing at the same time, because first of all, she thought she had a knockout point in relation to condition B in any event, and she should have at least given the Revenue an opportunity to consider that and withdraw. And in any event, even if it were necessary for her case to be heard at the same time as Mr. Archer, that doesn't necessitate the joint issue of proceedings. It could allow a joinder later on, as I'd already mentioned before the shorter adjournment.
At the simplest level, would you then agree with the point I was putting to Mr. McDonnell this morning, that just at a conceptual level, I mean, that the tax liabilities which were sought to be made good against both Mr. Archer and Mrs. Archer were analytically entirely separate, and there was no reason why they couldn't apply cumulatively. They're not true.
Oh, no, absolutely. That was the Revenue's formal position.
Yes.
I think what my learned friend was saying is part and parcel of maybe an attack on Mr. Archer was a sort of general Ramsey approach where you look at everything realistically. But with respect, I don't understand that. I mean, what Mrs. Archer did was quite clear. She required an option and sold it on. The only question was whether any gain she made. She clearly made a gain.
Yes.
The only question was whether that gain was taken out for the reasons set out in our summary grounds, either a combination of Section 58 and Section 144, so that's spouse and the provision for options,
Yes.
or as
Under the
my-
exception
for exactly qualified corporate
QCD.
body, exactly, so 115.
yes.
And we set that out in our summary grounds in this case as the two alternative routes.
Okay. And then, I mean, an allied point is, we were told that on no tenable view did she obtain a tax advantage. But why was it not a tax advantage to make a disposal of an asset for CGT purposes, which left her with a tax-free gain of £6 million odd pounds? Was that just the wrong kind of tax advantage
Well,
in this context?
Happily, we don't have to resolve that issue.
Okay.
I suppose the counter argument would be, and this is really the beef going towards condition B, is that before Mrs. Archer did any of this, she didn't have a tax problem to get rid of, or unlike Mr. Archer. Mr. Archer was trying to avoid income tax.
Yes.
Mrs. Archer was certainly a counterparty to the scheme, but on one view, you could either say she was just a mere counterparty, she wasn't seeking an advantage. On the other hand, she was essentially trying to wash out the CGT consequences of her husband getting that income tax advantage. Now, that is plainly a point which was arguable on the part of Mrs. Archer, and we would say, bearing that in mind, that went straight to the heart of condition B. That was plainly an issue which, if she were right, was a complete knockout point to her APN.
Yes. And before I forget, I mean, do we actually have, or have the revenue got a copy of the DOTAS notification which was received in respect of this scheme?
I'm sure we would, unless it's been destroyed. I think is the answer I can give now.
I see.
If it
Anyway, it's
were
not.
to sit-
I mean, it's not in evidence. So that doesn't
No,
seem to be
just so it exists, maybe my other lords, the way the DOTAS system works is that the question of notifiability is a question for the promoter.
Yes.
And what happens is the promoter is under an obligation to say, I've got this scheme. Revenue then issue that promoter a number, and then the users of the scheme separately have an obligation to put the scheme reference number down on their tax return. But for each user, it's the same number.
Yeah.
So the number only varies by scheme, not by user, if that assists in terms of clarity.
And I merely asked, on the face of it, it looks as though I mean, this doesn't appear to have been a widely marketed scheme. So I saw somewhere reference to only having been used by one or two people on a kind of bespoke basis. On the other hand, I'd have thought the fact that it involved Mrs. Archer as well as Mrs. Archer, Mr. Archer, may well have been central to the way it was put together in the first place.
Well, you certainly need somebody to be disposing of the valuable option tax-free. Now, a spouse is certainly one way, or you can rely on the statutory exemption.
Well, then it's got to be somebody you're
Conceptually,
happy,
rely on someone non-resident.
Somebody you trust.
somebody you trust and are happy to make a gift of several million
That's
pounds.
certainly true, yes. But that could be a non-resident trust. I'm speculating
Well,
here.
it could be
You're
all
not
sorts of
necessarily
things.
absolutely tied to the wife, but
No.
um,
Well, all right, it is tied to one of the arguments which, at any rate, according to the revenue, was being run on Mrs. Archer's behalf.
indeed. But I mean, I think the key point is there was, when you really break it all down, there wasn't. If you, yes, it would have been nice, absent any other factors, that they issued a claim form together. But bearing in mind the counter factors that she had, unlike Mr. Archer, a unique argument, which we've seen at paragraph 5.1, which went to the heart of the validity of the APN, and the fact that, as it were, she could catch up later, if need be. Prudence would have dictated holding off at least for a couple of months, just to see how that process worked out. Because the key point, I risk of repeating myself, is we're dealing here with an APN which was issued on the 4th of November, where the revenue conceded on the 22nd of December. We got nowhere near the time limit which came up at the beginning of February. Just dealing with some other points which might.
So you will provide us with copies of the DOTAS notice?
We will provide copies
Insofar as it's within your power. I
And
thought it will be through one means or another, you'll be able to get hold of it.
One minute.
Yeah.
So then just addressing some other points made by my learned friend. In terms of Hayworth and the other cases, we don't think those really assist. Those obviously all post-dated Mrs. Archer's claim. Mrs. Archer was one of the first, or if not the first, claimants in relation to an APN. So we can't now pray and aid what happened in those other cases to rationally justify a decision for precipitous litigation in this case. And secondly, in terms of paragraph 18, whilst of course, of Hayworth, whilst there is of course a short gap between the representations and the issue of the judicial review proceedings at paragraph 18, the Court of Appeal's reasoning in that case is hardly an endorsement on that behaviour, simply there's no comment upon it. In terms of other cases, as we record at paragraph 51 of...
We just don't know whether the point was taken, do we?
No. What we do know, or at least what I know, is, as we set out in our skeleton at paragraph 51, was the point was taken in Roe. But by the time permission in that case was granted by Mrs. Justice Rose, and by the time the full hearing came on before Mrs. Justice Simler, the Revenue had actually responded to at least some of the representations made, and there were, in Roe, as you can see from the judgment itself, there were much wider points about the natural justice and really an attack on the legislation itself, which plainly couldn't have been encapsulated within Section 222. We accept there must be some limits to Section 222, and a broad ranged attack on the legislation would be one such example. Then there's the Section 55 8c point, and over the short adjournment we have considered that, and the Revenue's position on that is this. In the very narrow circumstance which Mr. McDonnell has identified, on the face of the legislation, an APN issued after an appeal but prior to the question of postponement arising would take immediate effect. The Revenue in practice have never encountered that scenario. Insofar as an APN were in fact issued, it would have used the same form as any other APN, so would have actually said, we're not going to enforce pending the time you have representations. And in any event, we come back to Lady Justice Arden's point about common law duty to accept representations and so forth. And in practice, the Revenue would anticipate that they would have to give an opportunity for representations and hold off to enforce. But what we would emphasise is that that is not this case. On the facts of this case, which is an inquiry-based APN, it was entirely within Mrs. Archer's power to suspend the operation of the APN, because all she had to do was submit representations and wait. They didn't even have to be that very good representations. They just had, you literally had to make a representation to the Revenue, and that would be enough to engage the statutory stasis, to use Mr. Justice Green's terminology. So on the facts of this case, and really in the facts of virtually all APN cases, whilst formally the APN does trigger a payment obligation, in all cases it's entirely within the power of the taxpayer to suspend that immediately simply by writing a letter. And that is the relevant context we would submit, that you have to consider Section 222, at least on the facts of this case, and whether it is.
A purist would say that it suspends the obligation to pay under the APN, but it doesn't actually suspend the APN itself.
Well, I would accept that, my lord, but I've used purist in a slightly derogatory sense in my skeleton argument, because we are after all here not in a tax tribunal, we're here in a judicial review context where pragmatism and flexibility reigns. As I learned the first time I tried to take a pleading point in the admin court. So I would say that position, academic as it, academically right as it is, it doesn't really answer the key question we're having to consider in this appeal, which is really costs and the parties' behaviour.
Everyone's concerned with the obligation to pay rather than the strict validity of the notice.
If I may, just in terms of one point, I think which my learned friend raised with, again, perhaps a theological angst about the validity of the confirmation of the decision as opposed to the decision itself and which conditions you would have to satisfy in that context. It's not in the bundle, but it's a short passage by Lady Justice Black, as she then was, in a case called O and Hammersmith and Fulham. That's 2012, 1 WLR 1057, where she said at paragraph 18, often in JR, unlike in other contexts, you often have a moving target, and to the extent that through some remediation or complaints procedure, the decision is slightly altered, best practice is to deal with the most recent decision, because otherwise it's all academic. And this goes
I'm
again.
sure there are other cases where the same point is
It's
arisen.
a truism.
It has a. I mean, I haven't had the opportunity to track them down, but I mean, it's one's instinct in this sort of situation is where you have a right to make representations or some sort of claim procedure of some kind, is to say that it's the decision that arises out at the end of that claims procedure, which is the one which is capable of JR. Or putting it the other way, really the point that's made by Lord Steyne. You can't be shut out from seeking to JR the eventual decision by the argument that really Miss MacDonald made, which is, well, it's really the original decision that's the one which is being impugned.
Well, indeed, my lord, if you recall in the passage I took you to with Lord Steyne, he was addressing the Court of Appeal's reliance in that case on a case called Greenpeace, which did essentially insist upon, oh no, you've got to start with the first one because everything is ultimately iterative after that, and he clearly rejects that approach. So maybe if this matter were being heard 30, 40 years ago, the court might have a greater amount of sympathy with Mrs. Archer, but we're just not in that world anymore. So I think that's all I think I need to say about the first part of the case, the alternative remedy, and what my learned friend says about that. Briefly, I'd also just like to draw your attention to the alternative part of our case, which is that in terms of what the master did, he was clearly exercising a discretion and commenting more broadly on Mrs. Archer's behaviour. And so if I may, can I just take you to his decision and make some submissions about that? So that's in the core bundle behind tab 15. And it's a short decision. I accept the second paragraph, which starts just under the second hole punch, is dealing with alternative remedies or alternative steps. But what then follows, and this is what I rely on the skeleton, is really a broader point made about the general exhortation by the courts to only use judicial review as a last resort. And that is in particularly emphasised by the Master's citation of Cowell, which, as you'll recall, isn't really a case about alternative remedy at all. And on the basis that the Master was just exercising a costs discretion at large, it was plainly a decision which was reasonably open to him. And you'll recall in our skeleton we cite Lord Hope in the Furry case, where he says, well, that's a classic case management / judicial discretion question, which the High Court shouldn't interfere with unless there's been a clear error of law.
Well, it's really, isn't it? I mean, it comes down at the end of the day to the point at the bottom of page 125, the sentence beginning, on any objective analysis it was seen at the point of issue, there was significant potential for the situation to be resolved without the additional upheaval and cost of proceeding.
Indeed.
And that is classic, a classic scenario in which not just courts on JR, but any other sort of court, at first instance, would contemplate the possibility of making no order as to costs. Where it's quite apparent that there's been, as it were, over-aggressive litigation, which simply wasn't necessary when the parties could have discussed the matter and resolved it without the need for the cost of litigation.
And just for your note, Mr. Justice Green was, it appears, less convinced with that analysis, and I can just take you to the two relevant parts of his judgment. So the first is paragraph 3, which seems to suggest he's not going to interfere, because he says, insofar as his ruling is based upon conclusions about the conduct of the appellant, then this was secondary, but nonetheless amounts to an exercise of discretion which on appeal I would not wish to disturb. That's paragraph 3. But then, when we move to the end of the judgment, it's really paragraph 58. He records that he's less convinced about that. The reasons we've given, we would respectfully say that properly construed, and particularly by reference to the passage the Lord has just mentioned, and the citation of Cal, which goes to a far broader point about the party's conduct. We say that the Master was clearly exercising a wider discretion.
This sort of kicks in only if you, as a respondent's point, only if section 222 is not an adequate procedure. And so you have to support the exercise of discretion by, on the basis that you've lost on that.
Indeed, but even so.
Well, it's also the other. I mean, I think where you get to in terms of Cowell, is you say even if this court thought that there was a flaw in the exercise of the discretion, exercising the discretion knew we should reach the same conclusion because of the failure to comply with the pre-action protocol and all that sort of.
Well, conceptually, there you can get there two ways. First of all, what the Master was ultimately doing, his analysis wasn't dependent upon a strict alternative remedy analysis. He simply made a broad decision about costs. Now, if section 222 is not genuinely an alternative remedy, such as to require its exhaustion prior to the issue of proceedings, if I'm right about the construction of the Master's decision, that is irrelevant, because he's ultimately just exercised his discretion, which a higher court shouldn't interfere with. If I'm wrong about that, it's essentially both limbs playing together. So the section 222 alternative remedy part at least informed his decision to some degree. Then I entirely accept what you say, my lord, in that it's for you to remake it and all the points I've raised.
But do you or do you not say that the failure to follow the pre-action protocol on its own, if we're exercising the discretion of fresh, is an adequate reason for refusing Mrs. Archer her costs?
We would, against the context where section 222 is not an alternative remedy, but it is clearly highlighting a mechanism for you to engage with on that point of view. And you also have, so that's a specific reason to sort of engage in correspondence with the revenue, even if it isn't a formal alternative remedy. And then you have the wider point about the pre-action protocol in general. I don't accept that merely because you might formally decide that section 222 is not a formal alternative remedy, that then gets cut off in terms of your analysis of the exercise of discretion on cost generally. It clearly informs what a responsible litigant should be doing in those circumstances.
You may not be able to answer this, but was the Master's reference to Cowell because there have been written representations by the Revenue referring to it?
That I'd have to check. We actually have those in the supplementary bundle.
Oh, right.
It's tab 20. No, it wouldn't appear not.
No, we've obviously got it from somewhere. It's actually come across the point before.
So that's really what all I think I need to say about discretion. My lords, the Revenue is also conscious that Ms Justice Green sets out a postscript at paragraph 60 onwards. It may well be that you want to comment on that, it may well be you don't. I'm happy to address what the Revenue's thoughts on that are, but equally I'm quite happy to sit down. So I'm in your hands.
Just remind ourselves what they are.
Yes. Well, I mean, on the whole, I don't think it's a good idea for courts to speculate about situations that aren't in front of them, because whatever one says is going to be obiter, and based on an incomplete appreciation of the particular facts. So on the whole, my feeling is it's safer to steer clear of this kind of hypothetical exercise.
Thank you for the
There was a
offer.
very short, terse statement by Lord Justice Mummery in a case I can't now remember the name of, to exactly that effect.
Yes.
Do not decide anything you don't have to decide.
Very well. Unless Mr. Master has anything else. Those are my positions.
Thank you very much. Yeah, it's Mr. Lawrence.
My lord, perhaps this time if I start with the best point first. The my learned friend is not correct about in his analysis of the section 55(8)(b) point. He says it arises only if there's an appeal, doesn't arise in a case like this where there's an inquiry. He's got that the wrong way around. So in a case where there's an inquiry, when the inquiry concludes, there's going to be a closure notice and presumably then an appeal. And in a case where in due course the closure notice is issued and the taxpayer seeks to appeal it, that's precisely the situation where the taxpayer will be unable to obtain the postponement of that tax pursuant to section 55. So in this case, for example, that would have applied, as I submitted this morning, to Mr. Archer in relation to the closure notice issued to him in July 2015, and had there been one to Mrs. Archer, the same would apply in her case. So the APN would have had a legal effect prior to the conclusion of the revenue in response to the representations.
But in that example, he would have, and obviously in the end he didn't pursue an appeal, he just paid the tax. But if he had found himself in a position where he had to pay pursuant to the APN, the representation process having been exhausted, then, I mean, one reason why you couldn't get postponement, because you've already paid the money up front.
A practical difference.
As a matter of practice.
In that particular situation.
Yeah.
So if the timing was, as your lordship's put, the representations process concluded before the statutory appeal started, then that would be so. But as I submitted this morning, it might well be a year before the representations process concludes, as we see on the facts here. So there's quite a window within which there can be a closure notice and an appeal, and the taxpayer has a right to apply to the tribunal for the revenue to issue a closure notice if the revenue got no good reason for delaying any further in issuing it. The revenue can't prevent you from starting your appeal just by never issuing a closure notice. So, my lords, in no particular order, the submission's been made that in a tax case it's perfectly all right to wait until just before the conclusion of the 3-month period before issuing judicial review. It promptly isn't very important in a money-only case. I don't accept that. The authority on that, it's not in the bundle, but it's a well-known authority called Finn, Kelsey and Milton Keynes. Yeah. There's a reference to it in my skeleton argument below on page 85 of the supplementary bundle.
Just give us the reference.
So it's Finn, Kelsey, Kelsey, against Milton Keynes Borough Council 2009 Environment Law Reports 17. And the neutral citation is 2008 EWCA. We're just guessing it though.
Carry on in the meantime. I think you've
EWCA
given us enough to identify it.
Civ 1067.
1067. Thank you.
And that the paragraphs 21 to 25 in that contain a detailed discussion of the need for promptness. Recognise that the importance of promptness can vary from case to case, and in particular in planning cases it's very important because construction can start after 6 weeks. So there's a general, it's not a rule, but there's a sort of general approach in planning cases that you need to bring the jail within 6 weeks. And the position in other cases can vary. So in my own experience, for example, I had a case last year where, in a tax case, where the claim was 2.5 months after the revenue's decision and the permission wasn't granted because it wasn't prompt enough. Part of the delay in that case had been because the parties had waited to write a pre-action protocol letter. Right, anyway, just an example of the sort of thing that can happen. The point was made about it being a moving target in JR if a decision is updated or amended by the decision-making body. Fully accept that. So if representations have been made and decisions amended, then of course it's the amended decision which the court will then consider. But it doesn't follow from that the JR is still is not still examining the lawfulness of the original acts in accordance with my submissions. So although if you like, the target or the consequence, the practical consequence of the impugned decision might change a little bit, the unlawfulness that's being challenged is still the original position. And I accept that HMRC have to follow a lawful process, of course, in giving their representation's decision under 2224. But it doesn't appear in the statute to be subject to the same safeguards as the original decision. So, for example, the representation's decision does not have to be taken by a designated officer. The statute doesn't say it has to be taken to the best of the revenue's, best of the officer's judgment. And in my submission, all lawyers are familiar with this in practice. But lawyers are dealing with uncertainties in any case which is potentially going to go to the courts. There are uncertainties. In my submission, revenue would not, in response to representations, withdraw an APN where the revenue considered that they had an arguable case that was validly issued. The revenue are not going to remove their own right to use this recently acquired new statutory tool simply because the taxpayer's got some arguable points, or perhaps a good point, but it's not yet known. The revenues, I would suggest, it's clear that in practice what would occur is the revenue would confirm their APN and leave it to the courts to decide whether it was valid or not. They would want it to be valid. So, if you like, that's a different way of putting the point that I put this morning, that the revenue are not an impartial arbitrator in deciding on the representations. The revenue have an interest in maintaining the APN.
But you're not suggesting they could actually apply a different standard, are you, from the one they would have had to apply, I mean, the threshold test as to what they have to believe in order for for condition B to apply. I thought for a moment you were almost suggesting that they might.
I think I am. I think
you
I
are,
am.
but I find that surely that can't be right. I mean, the review has to be as to whether or not condition B was satisfied at the time the original notice was given. You can't, in the course of reviewing that decision, suddenly introduce a less stringent threshold which has to be crossed.
No, of course they have to consider condition B,
Yes.
challenge on condition B, but it's looking at section 220. It isn't clear that they have to adopt that procedure with as I say, the safeguards that it has to be a designated officer. officer until the best judgment.
Well, in that case, it wouldn't be reviewing the original decision, they'd be remaking it in accordance with different unspecified criteria. I mean, surely you can't derive that from the statutory scheme.
Well, I think it's very unclear from section 222 what
Well, it would be
what the criteria are.
whatever the position were under 222. One can't imagine a clearer breach of the duty of fairness or natural justice if having heard representations, they then make, as it were, make a fresh decision on a different basis. Then that would fall foul of all the things that Lady Justice Arden said in Roe.
Well, my lord, I think that what they actually do is they look at their original decision and they see whether there was some obvious error in it or some obvious illegality in it. And otherwise, their tendency is going to be to want the original decision to stand.
And you're asking us to infer that the Revenue Act unlawfully and sort of improperly, but I mean, I think that's really what it seems to boil down to, and I'm certainly not prepared to make that assumption.
No,
Well, my lord, without irrationality, they could examine their original decision and conclude that the original decision maker should be upheld. But I mean, I think I would ask you this one. The question arises: if it's not a designated officer doing the review, and the statute doesn't require it to be the designated officer, then what indication is there in section 222 that it has to be done to the same standard?
Well, the fact is that that's what this court has said in Roe. Lady Justice Arden has set out pretty stringent tests which has to be complied with by the Revenue in considering representations in the passage that we referred to, 110 and 111.
So it's inherent in confirming the decision. You can't confirm the decision by substituting your own decision on a different basis.
I think what I'm attempting to argue is that once a decision has been made, if we're reviewing it and in order to see whether we can confirm it or not, you don't remake it. That you're simply saying the revenue examining was there a valid basis on which the original decision could have been made. So in my submission, that's a lower test for them than to remake the decision to a high standard. I've made the point.
Thank you.
I do accept the point that's just been made by my own friend that in Mrs. Archer's case it wasn't certain that her condition B point was a good point. In other words, she could say, well, she didn't derive any tax advantage from the scheme, but the revenue had an argument that she did derive a tax advantage from it, and so that condition B wasn't a knockout blow in her case. But as I submitted this morning, it was one of her several arguments in the judicial review. My final point relates to Cowell and Lord Staines's judgment in Burnett, which I have here. So in both of those cases, the question the court was examining was not, in fact, what was the correct time for bringing the judicial review, but should it be stayed? Should it be stayed pending some other dispute resolution process? So in Cowell, paragraph 14, the entire discussion is framed in terms of whether the wheels of the litigation should have continued to roll, or whether the application for judicial review should be stayed. And in Burkett, there's the discussion again is whether the if you like, what's said to be premature claim for judicial review could be cured simply by staying it pending until the actual decision is given. And in my submission, those authorities actually support my case. In other words, the claimant who has time running against her, subject to express agreement from the other party to extend the time, possibly with a blessing of the court by way of an application as well. Subject to that, the claimant who has time running against her should issue and then seek an immediate stay if there's some other process going on in parallel. So the court is not required to look at the case until the other process has been resolved. If it's a movable target, then the movable target will have updated as a result of the parallel process. But the rules require the issue of the claim form to be within time, and that's axiomatic. And so there's a strong vein of authority. Cowell, Burkitt, the Zahid case, which is in tab 20, we haven't looked at it, but it's the case about higher educational authority. Again, the indication was that the claimant at least properly could, not necessarily should, but could issue and then immediately stay. And in my submission, that would be the appropriate course if the representations procedure is something that needs to be resolved prior to the court considering the judicial review, subject to any letters that may be written. Now, as regards letters, all we can do is look at the letters that were written in this case. And there were 3 letters from the claimant's representatives. 3 letters are in 3 letters at tab 4, tab 6, and tab 12 and 13. So in tab 4, the revenue are invited to agree with the analysis and withdraw the notices as soon as possible. It says pending that we intend to issue the application, but clear implication is that if the revenue respond favourably to that, then the application won't proceed any further. And for example, if they've responded immediately, then the application, the claim form would be served. But there was no response to that letter. In tab 6, the very sensible proposal was made to stay the proceedings. That's on page 25. No response from the revenue solicitor, no agreement that a stay would be sensible. And then later in January they were reminded of that, and they still didn't agree to a stay. And so the matter proceeded to Mr. Justice Mitting's decision on permission, refusing permission, and then the Order of Appeal granting permission. Now, so as I say, what we can see is that in the face of the letters which were written, they weren't doing precisely what this court is suggesting would have been the most appropriate course, which is to invite a time extension. But the indications suggest to me that the revenue wouldn't have agreed to that if it had been asked for, because sensible suggestions were being made and were not being accepted. The revenue, in my submission, the revenue's approach to this case was to fight tooth and nail, particularly if judicial review's been threatened. The revenue may very well reasonably take the view that a party might be deterred from its judicial review claim if the revenue don't grant a time extension, because then the party's up against a hard and fast time limit very shortly, and also faced with the prospect of incurring a large amount of costs, with no certainty that it'll get them back. In effect, if the revenue go around granting time extensions to everybody who's going to make representations, then you'd end up with potentially far more judicial review claims. So I don't have statistics. We can see from the decided cases that there have been about 5 cases decided about APNs. There was one case, the decision of Mr. Justice Darwin Cockayne, where permission was refused. So 5 or 6 cases where there have been judicial review applications. Of course, some of those cases involve groups of people, so I think Dickinson was about 1,000 people. But I don't know how many APNs there have been or how many representations there have been, but presumably many, many more the number of cases that are litigated. And in my submission, one of the reasons for that is that it's difficult for claimants to do what's needed to do to issue a judicial review claim, because they've got to serve the kitchen sink when they issue, because they've got to incur a lot of costs up front with no indication of where it's going to go, and because time is quite short, and by the time they've instructed lawyers, they're probably already quite close to the time limit. Whereas if they're given an extra year, or whatever it may be, 6 months, or whatever it may be, because time's extended until representations have been made and refused, then it's going to be much easier for a lot of claimants to bring claims. So anyway, those are my submissions in reply.
Thank you both very much indeed. Won't surprise you to learn that we won't give judgment straight away. They'll be issued in draft for you to suggest typographical and other minor corrections. If you can agree an order, so much the better. If you can't, short submissions in writing will decide it on the papers, and there'll be no need for anybody to turn the hand down. Thank you both very much indeed for your submission.